Professor Fiss, please tell us a bit, if you could recall the names of the people that you recommended to Mr. Dorr that he ultimately hired.
Well, I think I probably had the most decisive role in hiring people who had worked with him and with whom I worked during my time in the Civil Rights Division. Two people particularly come to mind. A woman named Dorothy Shelton, now Landsberg, now a lawyer, but she wasn't a lawyer. She's in the Civil Rights Division. She would be known as a research analyst. That's the precursor of paralegals. And the other person was Bob Owen. Bob Owen was someone that John worked with in the Civil Rights Division. He was his first assistant. He worked with him. He was the one that worked with John on the Neshoba case. And John adored him and respected, and I may have sort of urged him to take those two from the division. He didn't want a wholesale transfer, but he did want enough talent that he needed. And people like Bob Sack, people like Bernie Nussbaum, people like Hillary Rodham Clinton were people who I did not know, and he had his own sources of hiring these people. There may be some other members of the Civil Rights Division who followed him to impeachment. I probably was involved with that, but quite frankly, I don't recall who they were. Bob Owen and Dorothy, I remember the most because they worked around the clock with me. You know, we had a little office where all the stuff was coming into, and they were often in that office with me, and we spent a lot of time together.
Was there much of a debate?
Tim, could you just slide a little bit to your left? I'll get you just a little bit of your shoulder.
All right.
You just did a little weight shift on me, sorry.
Okay. Is that better?
Much better, thank you.
Okay. Was there a debate among the staff regarding the issue of high crimes and misdemeanors required an indictable offense? Was there a debate or read?
Well, one thing you should know is I often did not participate in the discussions of staff or the debate or the preparation of their views. So a debate in any formal sense, I just was not part of. I would say there was a disagreement and a very difficult decision that had to be made, and maybe the staff was divided among itself as to whether a crime was necessary or whether it was sufficient if there was some other impropriety. And some members of the staff may have taken the view that a crime was a necessary condition, you know, a crime in the sense of a violation of Title 18 of the United States Code. But ultimately, as you know, John took the position that it was not a necessary condition that there be a violation. So there was disagreement, debate among staff, I don't really know.
Okay. Do you recall Mr. Dorr telling you his reaction to meeting St. Clair for the first time? Or do you at least recall what he thought of Mr. St. Clair?
No, I don't.
Was Mr. Dorr
I mean, I did have conversations with him about Sinclair, and he was generally very respectful of him, but I can't recall a very specific conversation.
Did Mr. Dorr, when you started as a consultant, it wasn't clear yet what kinds of information you would be receiving from the special prosecutor, or the White House Special Prosecution Force. When you were, I know I'm taking it back a long time, but it is, I think, significant. When you were thinking about the process of, you wouldn't call it discovery, but collecting information in the beginning, how did you think, or did you assume that that Jaworski's office would hand over material? I mean, was that a basic assumption when you began, or did you think you'd have to do investigations of your own?
Well, by the time I began working, commuting down from Chicago there, the basic decision was taken, namely that there would not be an independent investigation, but that we would be dependent on the investigation of all other agencies or institutions. That our task would be primarily a collection and synthesis of the information that was made available by other Senate committee, investigating, special prosecutor, all of those things. That decision was already made. Now, one decision that was not made, but was made while I was there, well, it was unfolding, was the tapes. I mean, the tapes were not available before January. Remember, the tapes become available, I guess, in the spring of '74. There's an 18 minutes that are missing, but the tapes, I think, were released by President Nixon in the spring of '74.
April 30th.
Okay. When they were released, it seemed kind of innocent. And one investigative thing that John did do was to get hold of those tapes, the ones that were released, and go over them with recording technology that would pick up conversations and parts of conversations that were omitted from the printed version of the tapes. And as you recall, the committee, I think this happened in July, not the committee, the impeachment staff released a different version of the tapes, different than the one that President Nixon released, and that was of tremendous public significance in terms of the committee members were just sort of, shocked with some of the things that appeared. So that was a very important moment in the history of the inquiry. And that could be considered like an independent investigation, so that much was done.
Some of those tapes, I believe, were included in the materials that the Special Prosecution Force handed over in March, weren't some? Because didn't they hand over to the impeachment inquiry the 8 tapes that they received from the White House in 1973? The smoking gun, not smoking gun, I'm sorry, the Cancer on the Presidency tape, the March 21st, 1973 conversation between the President and John Dean, was handed over after the Saturday Night Massacre by the White House in response to the
Yes.
public outrage.
Yes.
I believe that was part of the collection of materials that was passed to the impeachment inquiry in March.
Yes. But I was referring to the retranscribing of the tapes that were released by the President in April of that year.
Well, I was going to ask you whether you listened to yourself any of these tapes.
I've never listened to a tape. Never, all the time I worked there.
Okay.
I mean, they were available, but I just relied on, I made great use of the tapes, but I didn't listen to the actual voice. I relied on transcriptions that had to be checked and double checked, but I never listened. To this day, I've never listened to a tape. I mean, I've read the transcript dozens and dozens and dozens of times, but I never listened to it.
They're the primary record. You may find them interesting.
I'm sure.
There was also a question of whether to issue a subpoena or not. Was there not? To obtain more information. Was there ever a question that the House would not issue a subpoena for information?
I was not involved in those discussions. I mean, I don't think if I were there, I would probably be included. But remember, I'm trying to teach my classes at Chicago.
that's right.
And so I just came in. John says we have to file this memorandum on the grounds of impeachment. When can you be here, or stuff like that. But I'm sure anyone that worked there full time would be involved in that.
Tell us what you can remember, please, then, of your role in shaping the 5 articles, ultimately, that would be voted on by the committee.
I drafted all of the articles and wrote the information that was used in support of it. Obviously basing it upon all the work that the staff had been doing. The most interesting, and of course involved in that process, I had views about them. Now the most interesting discussion, and what should be included and what not to be included, the most interesting discussion was on Article 3. Article 3 was to make the grounds of impeachment the refusal of the president to cooperate with the Senate investigation. John conferred with many people about all during the process, and one person that he greatly respected, admired, I don't think it's any secret, was Burke Marshall. And Burke Marshall was of the view that he was uneasy with Article 3. He thought Article 3 was had a tinge of compelled self-incrimination. And from that perspective, he was very reluctant. And I took the position in discussions with John. I had never met Burke Marshall as of that moment. Although he was later to become my colleague at Yale, I had never met him. John always conferred with him. I mean, many evenings I would spend in John's office in the Civil Rights Division when he would be speaking to Burke Marshall and I would be the other person in the room listening to it. So I knew Burke Marshall's viewpoint, but I took the opposite viewpoint and defended Article 3 as an appropriate ground of impeachment, essentially because I didn't think it was incrimination, but it was a continuation, it was a condition for the continuation of the exercise of power by the president. Article 3 was in fact included as one of the grounds, and when I went to Yale, I got to know Burke Marshall extremely well, and he was a friend and colleague until his death. I was very close to him. I think to his last day, he always teased me about supporting Article 3.
Let's talk about Article 4. Why was that included?
What was Article 4 again, Bruce?
The secret bombing, I think, of Cambodia?
Yeah.
Can we just wait till the siren?
Do you care about the siren? It's getting kind of, I can hear it.
Oh, okay, well, we'll wait, although it does give a sense that this is happening in a city. And they're live. There we go.
I'm sorry.
But just, I'd like to know.
What was the final vote on Article 4?
I believe it was a party line vote.
Right.
My question is to understand your role. How did Mr. Dorr decide which articles to place before the committee for its for its judgment? Tell us if you can remember the process. I mean, you said you worked on all 5 articles, but how was it decided there would be 5 articles and what their substance would be? How did that happen? Or what did you see of that process?
Well, I'm sure he was conferring with Bert Jenner. Remember, he's the minority counsel. And I think he was conferring with Rodino, Congressman Rodino, who was the chair of the House Judiciary Committee. He's conferring with a lot of people. My view was that, remember, let's go back to the grounds of impeachment. I did not think that you had to violate a criminal statute in order to be a grounds of impeachment. I don't think it was an independent requirement. On the other hand, and you could see this in the brief on the grounds of impeachment, I thought it had to be something more than a policy difference. It had to have crime-like elements to it. It had to have a kind of moral core about the impropriety of doing it. And my view was essentially that Article 3, we had this difference of opinion, and I think he went with it. But after we left Article 3 and moved to Article 4, that fell on the other line of an appropriate grounds of impeachment. So I don't recall exactly John Doerr's position, but my hunch, my recollection, as best I can say, he was not personally committed to that ground basis for impeachment for reasons that I just articulated. But I think he found himself under a duty to be more inclusive what he gave the congressman. I think it must have been, I was not party to any of that conversation, so I don't know it, but it must have been that Rodino wanted to have that before the members. And John, he's an independent person, but he realized that he was the head of the staff and that Rodino had to make the decision. So I think I'm not sure actually what he thought about Article 3 in the final analysis. He doesn't elaborate long, but I do think that he was probably more in favor of that, or he could see that argument, but really was very cool towards Article 4 and probably included it for purposes of complying with the mandate from the chairperson.
Since they're so important to the story, again, I apologize, it's a long time ago, but when you came in to work on them, were you handed a draft, or did he say to you, Owen, we're going to do 5, and they'll touch on these issues: abuse of powers, obstruction of justice, bang, 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 and then you went and did the first draft, or was there a draft given to you which he wanted you to comment on and edit?
Drafts came in, never saying there's 5 grounds. I mean, these things would come in. Some of them were shaped by the writing process. I mean, really, of collecting all the information to sustain this. And I never had a vision when I began that there would be 5 articles of impeachment. I began with 1 and massed all the information. There were people pulling stuff together, but putting it all together into this information, this report that was going to be submitted. And then we did 1, then 2, then 3. He would react, and then 3. Burke Marshall would, weigh in on it again, and then we'd go back, and I'd make this adjustment or that adjustment, and Bob Owen would look it over, and it's almost endless. So it wasn't the sense of a preconceived plan. but let's see how it writes, let's see how it holds up, what's the best we can do to make this viable for the committee. But I never had the sense, oh, we have 5, let's start doing it. It was more step by step, really.
Do you remember when this process begins? Is it this part of basically you start with 1 and move to, are we talking about May, the time that he's laying out the statement of information, or is it June, or is it even in early July?
Well, I think it starts in May, picks up a lot in June, and the heart of it is July. The heart of it is July. Remind me, when was the statement of information submitted?
That's in May. That he starts.
No, he starts, but it's not submitted to the committee.
Well, the DOR starts presenting the staff the statement of information on May 9th.
To the
committee, in
committee.
executive session.
Right.
And that goes on for about 6 weeks.
Right.
So he's laying out the volumes which presumably you've looked at before.
Well, I don't want to, when you say I wrote them, believe me, the staff had a lot to do with it, but I was like the last step before. So I think it's May. But now, when is the grounds of impeachment filed? March?
February.
February.
So you work on, that's the first big document
That
you
was
work
the first. That was my first work.
Okay. When did you, and it's in working on that document that you yourself conclude that there are grounds for impeachment?
Yes.
And at that point, when you're working on that, you don't yet have a sense of how many grounds there are for impeachment?
No, but I know my views are beginning to take shape about the bombing of Cambodia. These things are
That
all
it's
being
not.
discussed. Yeah.
That it is not, that it's a policy
Yeah.
difference.
Because I'm working on this memorandum for the grounds of impeachment, but by that time I have a picture of the whole and what people are thinking about. I'm working on it, but I know its application to this context. I have a glimpse of it.
This is before the committee. I'm sorry, before the inquiry gets the material from Jaworski. So back when you're working on this initial statement, what are the things that you know about? Because you don't know the tapes. What are the things you know about that will give you the sense that there's been an abuse of power here?
I'm not sure if I can recall what I knew then as opposed to the end. I mean, it's sort of it's a little bit based on maybe what the public knows, not more advanced, begins to be categorized in different forms: abuse of power, refusal to cooperate with the committee. Remember, the United States versus Nixon is going through the court at this time. But I can't tell you what I knew then as opposed to what I knew later. It's all sort of.
Let me rephrase this. Maybe it's a more helpful way. What do you remember learning that sticks out in your mind and sort of you attach to sort of obstruction of justice, abuse of power? What were the things that you learned that you thought, aha, this is solid evidence of an impeachable offense?
Well, maybe this would be the best way of conveying it. I remember working on the statement of information very late in the process and trying to put the pieces together. And I worked hard to be careful about it. I mean, and I perhaps overcompensated and had sort of, this person is the President of the United States kind of deference. And one night, I'm working, I don't remember if it was Article 1 or Article 2, but I was convinced that if we did not have what was in the tapes, it wouldn't fly. I mean, I just knew it. I just knew that I worked. I mean, I put all the pieces together, every little tidbit, but this was the President of the United States that we're dealing with. And I genuinely said, my God, if we didn't have this statement in these now retranscribed tapes, this article would collapse. There wouldn't be any basis for it. And it was something about the, it was the limits of circumstantial evidence when you're dealing with the President of the United States in impeachment. You had to have some admission or quasi-admission in order to make it fly.
Well, without the tapes, there are a lot of dots that couldn't be connected.
It couldn't be connected in the mind of a kind of impartial, neutral arbiter. I mean, you could make charges, I guess, but you couldn't. It wouldn't be convincing, given that you're dealing with. I mean, maybe if you're dealing with a minor official, or if you're even possibly. I mean, his function. This was not a criminal proceeding, but it functioned a little bit. You applied to him a beyond a reasonable doubt, and it was necessary. If you didn't have the tapes, I don't think you could meet that kind of. A doubt would persist, and given that you're dealing with the President of the United States, you shouldn't do this.
Wasn't one of the challenges that though you saw a pattern, you could still make the argument that there were zealous lieutenants doing things that he didn't know about or didn't want to have happen?
You could make the argument. I don't know if I believe that argument, but it was the doubt that kept going. Right? You could make that argument that this was all, maybe he just turned a blind eye, or but you needed that extra increment of evidence to make it really convincing.
How tight do you feel the case was at the point that you delivered it to the committee for its
Ironclad. Ironclad. I believe.
Was it, did at any point Mr. Dorr convey to you a concern that perhaps there wouldn't be a bipartisan majority for an article? Or was he convinced that there would be some Republicans who would support at least one of the articles? Or did he not talk about this at all with you?
We talked about everything, but I never recall a conversation where he put it in terms of bipartisan, getting these people to vote on, the Republicans to vote on it. But I would say his overriding mission, his overall conception, although he didn't talk about what this Republican or that Republican vote on, his overall conception that we had to do this in a way that transcended partisanship. I think just the party vote on Article 3 was probably deeply disappointing to him, although it's not clear how attached he was to that article at all. But he always conducted his way to make this a bipartisan product. It was absolutely crucial that Burt Jenner was on board. It was absolutely crucial that Burt Jenner would sign the brief or the memorandum on grounds of impeachment. I mean, he always had this vision of being as much, of transcending party differences. And so I'm sure he would be deeply disappointing every time he didn't achieve that.
Well, he must have been disappointed then with how some Republicans treated Burt Jenner.
Yeah,